Defendant argues that plaintiff's paragraph 9 is not lawful and defendant cannot be sued for libel per Southeast for questioning everything. Plaintiffs failed to state laws prohibiting defendant from questioning everything. Defendant maintains that the right to question everything is granted and guaranteed in the First Amendment of the Constitution. Defendant argues that the United States and New York constitutions grants every person the right to participate in government, to speak freely on public issues, and petition government for redress of grievances. Yet, plaintiffs are suing defendant for exercising these basic constitutional rights. Plaintiff's lawsuit is a textbook frivolous and SLAPP lawsuit and must not be allowed to proceed. Plaintiff Brian Rourke, being an elected town judge and held to a higher standard, is using the power of the judicial system via this SLAPP and frivolous lawsuit as a weapon against defendant, especially since plaintiffs are attorneys, having unlimited resources and very familiar with the legal process. Defendant is a layman, who lost everything in the fire, does not have the financial means, resources, and knowledge to mount a defense. Based on all or any of the above answers to plaintiff's paragraph 9, defendant respectfully requests that the court dismiss this complaint with prejudice based on no factual issue of law are in question and plaintiff's failure to mention any law that prohibit defendant and others from questioning everything. The burden of proof lies with plaintiffs, which they have failed to meet in this verified complaint, and therefore, this lawsuit is without merit and should be dismissed at an early stage. Answering the allegations of paragraph 10, A, B and 11 of the complaint herein, defendant affirms in part based on knowledge of the incident. Plaintiff's paragraph 10A, B and 11, states that during a period of 3 or 4 consecutive days, including February 9 and 10, 2013, the defendant caused to be published on the Facebook website of the Internet a proposed complaint to the New York State Committee on Professional Standards accusing the plaintiffs of certain wrongdoings, including A. mishandling of client funds, disappearance of $22,000, and B. bid rigging, pricing, sixing at Sullivan County auction. Paragraph 11 states a copy of such proposed complaint, labeled Preliminary Inquiry, is set forth as Exhibit A to this complaint. Defendant maintains that upon information and belief, the statements made on the privileged attorney complaint form are true and made without malice. The truth cannot be libelous and malicious. However, it is plaintiff's burden to prove that it is false, which they have failed to prove. Plaintiffs have no evidence proving defendant's involvement with publishing the privileged document and whether such document cannot be posted on the Internet. As for CPLR Article 14A, 1412, the burden of proof lies with plaintiffs and they have failed to meet that burden. Defendant does not have to prove anything. It is plaintiff's responsibility to prove that the statements made on the attorney complaint form are false and whether defendant cannot publish a privileged document on Facebook. The facts entitle defendant to a verdict in his favor as plaintiffs have failed to meet the burden of proof. Lawyers must not only keep their clients' funds separate and inviolate, but must also be prepared to account fully for each client's funds at any time. An attorney pocketing clients' funds is a serious offense. The Office of Court Administration is encouraged to exercise the right to conduct audits of attorneys' accounts. Plaintiffs failed to join the necessary others, third parties that may be involved with posting of the privileged document, which they have the right to do. Defendant asks the court to dismiss this action because the absence of third party may prevent full adjudication of claims asserted. The court should not proceed in the absence of others, who should be a party. Fearing reprisal from the Board of Managers and plaintiffs for posting, writing, reading, and exercising our right to free speech, such as this lawsuit, it was decided, from the beginning, to distribute the password among many. Defendant is not the only one with the password and not the only one posting on the Facebook page, Grandview Palace, New York. Contrary to plaintiff's beliefs, defendant does not control who or what is posted on the internet. However, it is plaintiff's burden to prove defendant's involvement, locate, and join the other third parties as per CPLR 3211-A. After many attempts to get plaintiffs to perform their fiduciary and ethical duties, to represent the HOA as true attorneys have failed, defendant filed an attorney preliminary inquiry form with the State of New York, Supreme Court, Appellate Division 3rd Judicial Department, Committee on Professional Standards. See Defendant's Exhibit 8. The form was completed and filed with the Supreme Court Appellate Division on or about February 6, 2012. The attorney preliminary inquiry form attached here as plaintiff's only Exhibit A, falls under the absolute privilege documents and therefore exempt from libel per Southeast Wiener v. Weintraub. The document was filed to the State of New York, Supreme Court, Appellate Division, 3rd Judicial Department, Committee on Professional Standards, using the special form designed for attorney complaints. Defendant is seeking assistance to investigate aggrieved acts of plaintiffs, and as being such, is subjected to all rights, privileges, and protection under the First Amendment, New York State Civil Rights Laws, Wiener v. Weintraub. New York Civil Rights, Article 7, 74 Privileges in Action for Libel, states a civil action cannot be maintained against any person, firm or corporation, for the publication of a fair and true report of any judicial proceeding, legislative proceeding or other official proceeding. Plaintiff's Exhibit A is a true and fair publication of the currently active judicial proceeding against plaintiffs, which was posted on Facebook and therefore, cannot be the cause of action, under CPRL 3211. This lawsuit should be dismissed for failure to state a cause of action. Absolute privilege is a privilege that immunizes defendant from lawsuit, no matter how wrongful the action might be, and even though the action might have been done with improper motives. Where the defendant has an absolute privilege, the plaintiff will not have a viable cause of action against him, even if he can prove that the defendant acted with malice, that the defendant's statement was false, or that the statement was widely published. Plaintiff's actions by filing this lawsuit are deplorable and evidence of a narrow-mindedness and mean-spiritedness act on the part of attorneys. By filing this lawsuit, knowing that evidence for this lawsuit will negatively affect the $74 million insurance claim, plaintiffs created a level of mass hysteria and outrage amongst the population of Grandview Palace and is definitely an act of bad faith, especially for the victims of Grandview Palace. Defendant hereby moves for an immediate summary judgment in defendant's favor based on CPRL 3211.